Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Yes, we have an exciting show for you. We're going to be discussing alien registration, what it is, and should you register. So please listen and share the information with your friends and family members.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with this week's immigration news based on an article by Brian Figueroa, Esquire. New DHS Alien Registration Rule, a 2025 compliance analysis. On March 11, 2025, the U.S. Department of Homeland Security, DHS, unveiled a draft interim final regulation, IFR, that reshapes the framework of alien registration in the United States, implemented through the new Form G325R. This rule enhances compliance tracking by integrating online registration, biometric data collection, and mandatory documentation requirements. This segment provides a comprehensive analysis of the policy's scope, compliance obligations, and potential legal ramifications for foreign nationals and immigration professionals. Policy overview, purpose, and implementation. The initiative stems from long-established requirements in the Immigration and Nationality Act, INA, specifically under 8 USCIS 1300 and 11306. However, the current rollout marks a shift toward digital submission via USCIS online accounts, mandatory fingerprinting appointments, enforcement through fines and criminal penalties. The new registration policy took effect on April 11, 2025. The deadline to register is May 10, 2025. Under this new mandate, the following categories are now subject to registration: Canadian visitors who entered at land borders without an I-94, foreign nationals without inspection, EWI, individuals paroled into the U.S. without evidence of registration, minors who turned 14 while in the U.S., foreign nationals with denied or pending petitions without fingerprinting history. Who is exempt? Some individuals are specifically exempt: U.S. citizens, American Indians born in Canada with 50% American Indian blood, members of the Texas Band of Kickapoo Indians, diplomats, and certain non-immigrants under A, G, or NATO classifications. Form G325R, data collection and process. The G325R requires comprehensive personal and legal details, current and historical addresses, immigration and arrival data, full criminal background disclosure, biographic details, race, ethnicity, physical traits, family, and marital information. Registration Steps 1. Create or log into a USCIS account. 2. Complete and submit Form G325R online. 3. Attend a biometrics appointment, fingerprints, photograph, signature. 4. Download the proof of alien registration certificate. Penalties for non-compliance. Failure to register or update information can lead to severe consequences. Violation fine penalty. Willful failure to register up to $5,000 up to 6 months imprisonment. Failure to notify address change up to $5,000 30 days imprisonment or removal. Not carrying proof of registration 18 plus. Up to $5,000 up to 30 days imprisonment. Note, guardians are liable for failure to register minors. Special considerations for minors and exceptions. Children must register within 30 days of turning 14. Fingerprinting exemptions apply to individuals under 14 or over 79, diplomats and representatives of international organizations, those who depart within 1 year while maintaining valid non-immigrant status. Proof of registration. Acceptable documents. Acceptable forms of registration proof include I-94 or I-94 Govi, even if expired. Forms I-485, I-687, I-698, and others, even if denied, provided fingerprints were submitted. Employment authorization documents, EAD. Notices of deportation/removal proceedings, EG, I-862. A valid entry visa with an admission stamp. Lost documents and repeat entries. Lost registration must apply immediately for a replacement. Re-entry. If an I-94 doesn't allow multiple entries, a new registration may be required after re-entry. Operational concerns and practical pitfalls. Technical limitations. Canadians must select Entered without inspection due to a drop-down limitation in G325R. Digital I-94s might not be accepted during enforcement encounters. Mobile devices storing documents may be subject to broader CBP searches. Legal ambiguities. USCIS has extended acceptable proof beyond CFR listings, creating potential inconsistencies. A 2025 case, USA v. Flores, marked the first criminal filing under the new rule. Address changes and ongoing responsibilities. All registrants except Visa P and A/G visa holders must report any change of address within 10 days. Failure to do so can lead to criminal charges or removal proceedings unless excused by valid circumstances. Conclusion. The 2025 Alien Registration Regulation modernizes a decades-old policy but introduces significant compliance challenges. While digitalization and biometric checks enhance accountability, technical flaws and broad enforcement power could jeopardize fair treatment for many foreign nationals. Attorneys, employers, and immigrants must work proactively to meet the new obligations, maintain documentation, and monitor any changes in DHS implementation strategies.
Warning. Under President Trump's new 2025 registration rule, all qualifying non-citizens must register and update addresses or face fines, arrest, or deportation. Don't risk your status. Schedule a consultation with the law firm of Figaro & Associates at 855-768-8845 or visit www.askthelawyer.us. Stay informed. Stay protected.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with a special immigration report. But first, here is a representative from Department of Homeland Security.
Zach McCarthy.
Good morning. I'm Michael McCarthy, the Special Agent in charge for Homeland Security Investigations in Maryland. I'm here today to announce the results of a significant investigation into an extensive marriage fraud scheme designed to exploit our immigration system. This joint operation, led by HSI Maryland and U.S. Citizenship and Immigration Services, with support from the U.S. Attorney's Office for the District of Maryland, has uncovered a sophisticated network of individuals who recruited, enticed, and groomed U.S. citizens, encouraged them to enter into fake relationships and fraudulent marriages, and submitted false representations to USCIS to unlawfully obtain immigration benefits. In March 2025, our team charged 4 individuals in connection with this large-scale conspiracy. These individuals weren't just coordinating marriages. They were profiting significantly, charging foreign nationals anywhere between $20,000 and $40,000 per arranged union, and generating an estimated $4 million in illicit proceeds. These arrests mark a critical milestone in our broader effort to dismantle a criminal network undermining our nation's immigration laws. But the investigation didn't end there. Through persistent and coordinated investigative work, our agents identified over 100 cases in which immigration benefits were sought through fraudulent marriages. To date, USCIS has denied over 100 petitions or applications filed by or for the benefit of these foreign nationals. Just yesterday alone, with the assistance of USCIS and the Diplomatic Security Service, federal agents arrested 10 foreign nationals, individuals who knowingly participated in these schemes. We are actively working to locate and apprehend the remaining participants. Let me be clear. This is not a victimless crime. Marriage fraud compromises the integrity of our immigration system, it diverts critical resources, and it erodes public trust in a process that countless others follow legally and in good faith. This investigation remains active and ongoing. We are continuing to work closely with the U.S. Attorney's Office and USCIS to identify all those involved and to pursue prosecution to the fullest extent of the law. We strongly encourage anyone with information related to this investigation to come forward. We are committed to rooting out fraud and protecting the legal immigration pathways that individuals and families depend on to build their lives in this country. Finally, I want to express my sincere gratitude to the dedicated investigators, analysts, and prosecutors whose tireless efforts brought us to this point. Their professionalism and determination were instrumental in uncovering and disrupting this criminal enterprise. Thank you very much.
And here is the analysis, Operation Bargain Brides. Analysis of USCIS and ICE marriage fraud investigation. In an important crackdown on immigration fraud, U.S. Citizenship and Immigration Services, USCIS, in coordination with U.S. Immigration and Customs Enforcement, ICE, recently helped dismantle a nationwide marriage fraud operation. The case highlights both the complexities of immigration enforcement and the sophisticated strategies used to exploit legal loopholes. This analysis will delve into the story's major developments, the broader legal implications, and the significance of the investigation in the context of U.S. immigration policy. Background: in April 2022, Homeland Security Investigations, HSI, Maryland's Document and Benefit Frauds/El Dorado Task Force launched an investigation with support from USCIS. They discovered a coordinated scheme where U.S. citizens were paid thousands of dollars to marry foreign nationals, thereby helping them fraudulently obtain immigration benefits. 3 New York City residents, Ella Zurin, Tatiana Sigel, and Alexandra Tak, were identified as key facilitators. Shanta Hopper of New Jersey also played a major role by recruiting women to participate in these sham marriages. By April 24, 2025, 10 individuals had been arrested, with indictments issued against 4 major conspirators. As a consequence, the fraudulent immigration benefits granted through these sham marriages have been revoked. Analysis of key points. Marriage fraud is not merely a violation of immigration law. It is a federal crime under 8 USCIS 1325, punishable by up to 5 years in prison and a fine of up to $250,000. 1. Facilitators, recruiters, and participants alike can face serious legal repercussions. In this case, the elaborate organization of fake marriages, including falsified health records and immigration paperwork, signals the level of sophistication involved. Further research reveals that marriage fraud remains a persistent concern for immigration authorities. A 2020 report from ICE noted that an estimated 30% of all marriage-based green card applications might involve some degree of fraud too. Past operations like Operation Not So Fast 2019 showed similar multi-state conspiracies, reflecting how these crimes often involve networks rather than isolated actors. 3. Notably, this case emphasizes the importance of inter-agency collaboration, particularly between USCIS-ICE and the Diplomatic Security Service. Their combined resources enable more thorough investigations and successful prosecutions. Legal and immigration implications. The dismantling of this fraud operation underscores the government's broader efforts to protect the integrity of the U.S. immigration system. Fraudulent marriages undermine public trust in legal immigration pathways and potentially open avenues for other crimes such as human trafficking or financial exploitation. This case could lead to tighter scrutiny of marriage-based immigration petitions, more interviews, and expanded background checks. Immigration attorneys often warn clients that legitimate marriages must withstand rigorous vetting, including proving a bona fide relationship through shared finances, cohabitation, and personal testimony. Moreover, the successful revocation of immigration benefits obtained through fraud sets an important precedent, reinforcing the consequences of circumventing lawful immigration procedures. Conclusion: the USCIS-ICE investigation into a national marriage fraud ring represents a strong stance against immigration fraud. Through strategic interagency cooperation and diligent investigation, authorities dismantled a complex criminal enterprise. Future enforcement efforts will likely build upon such cases to ensure that marriage-based immigration remains a credible and lawful path for genuine couples.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa & Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Family member overseas that you want to bring to the United States, the law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figueroa & Associates, your trusted partner in family immigration law.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Why U.S. citizens with foreign property should consider creating a trust. Estate planning can be complex even when all assets are domestic. But for U.S. citizens holding real property abroad, it becomes especially critical to plan ahead. One of the most strategic tools in this context is the creation of a trust. At Figueroa and Associates, we routinely help clients navigate the legal intricacies of cross-border estate planning to ensure that their assets, at home and overseas, are protected and passed on according to their wishes. Understanding the global estate challenge. When a U.S. citizen dies owning real estate in another country, several issues arise. Foreign probate laws may apply, which could conflict with U.S. estate plans. Multiple probate proceedings may be required, one in the U.S. and one in the country where the property is located. Inheritance taxes or fees may be imposed by the foreign jurisdiction. Beneficiaries may encounter legal delays, unfamiliar procedures, or disputes across borders. These issues can lead to significant costs, delays, and legal uncertainty, especially in countries with rigid inheritance laws that may override U.S. wills or ignore informal family arrangements. What is a trust? A trust is a legal arrangement in which one party, the trustee, holds and manages property on behalf of another party, the beneficiary, under instructions provided by the person who creates the trust, the grantor or settlor. Trusts can be either revocable, can be changed during the grantor's lifetime, or irrevocable, fixed once established. Why use a trust for foreign property holdings? For U.S. citizens who own property abroad, creating a trust offers several compelling advantages. Avoiding foreign probate. Foreign property included in a trust is not subject to the probate process in the country where the property is located. Instead, the trustee can manage or transfer the asset according to the terms of the trust, bypassing costly and time-consuming legal proceedings in a foreign jurisdiction. Privacy and control. Wills go through probate and become part of the public record. Trusts, by contrast, remain private. This allows the grantor to control the distribution of their assets discreetly and without public scrutiny. Tax efficiency. While each country has its own taxation rules, a properly structured international trust can help minimize estate taxes, both in the U.S. and abroad. Some countries may impose inheritance taxes that can be reduced or avoided through advanced trust planning. Protection from forced heirship laws. Many countries, such as France, Spain, and many in the Caribbean, follow forced heirship rules, which restrict how a property owner can distribute their estate. A trust can sometimes legally sidestep these limitations, giving the grantor more control over who inherits what. Asset protection. A trust can help shield assets from creditors, lawsuits, or marital disputes, a significant concern for beneficiaries who may reside in jurisdictions with different legal protections. Case example: a Caribbean property owner. Consider a U.S. citizen who owns a beachfront villa in Jamaica. Upon their death, Jamaican probate proceedings would be required to transfer the property, possibly subjecting the heirs to local laws, court fees, and delays. However, if the villa is titled in the name of a U.S.-based revocable living trust, the trustee can manage the property or transfer it immediately to beneficiaries without involving the Jamaican courts. If structured properly, the trust can even plan for ongoing maintenance, rental income, or a future sale. Legal considerations when creating a trust for foreign property. While the benefits are clear, creating a trust for international assets is not a one-size-fits-all solution. Key legal considerations include foreign recognition of trusts. Not all countries recognize foreign trusts. Countries like the UK, Canada, and some Caribbean nations generally do. Others, like Germany, Japan, or France, have more limited or no trust recognition. In such cases, alternative structures, like foreign wills, local trusts, or civil law foundations, may be necessary. This is where experienced legal counsel becomes indispensable. Property titling and transfer. The foreign property must be legally retitled into the name of the trust, which may involve local attorneys and compliance with real estate laws in the property's country. Failing to retitle the property properly will leave it outside the trust, subjecting it to foreign probate. Reporting requirements. U.S. tax law imposes strict reporting obligations for foreign assets held in trusts, particularly for irrevocable trusts or those involving offshore trustees. Failure to report can lead to significant IRS penalties. At Figueroa & Associates, we ensure that our clients remain fully compliant with both U.S. and foreign laws when transferring property into trust. How Figueroa & Associates can help. Our firm, located in Brooklyn, NY, provides comprehensive estate planning services for clients with international holdings. We specialize in creating customized trusts that accommodate both U.S. and foreign legal systems, assisting with property transfers into trusts across jurisdictions, ensuring IRS and foreign tax compliance, coordinating with local legal professionals abroad, drafting companion documents like durable powers of attorney, pour-over wills, and letters of instruction. Our mission is to protect your legacy, simplify the inheritance process for your heirs, and avoid costly legal entanglements. Conclusion: plan today, protect tomorrow. For U.S. citizens with foreign real estate, the decision to create a trust is more than an estate planning strategy. It's a safeguard for your family's future. By avoiding foreign probate, minimizing taxes, and respecting your personal wishes, a trust offers clarity, control, and peace of mind. Don't wait until it's too late. Schedule a confidential consultation today with the law firm of Figueroa & Associates to protect your international assets and ensure a smooth transition for your loved ones. Visit us, 26 Court Street, Suite 701, downtown Brooklyn. Call now, 855-768-8845. Learn more. AskTheLawyer.us.
Attention paralegals. Figueroa & Associates, a top Brooklyn law firm, is hiring a wills, trusts, and estates paralegal. If you have at least 2 years of experience in estate planning, probate, and trust administration, we want you on our team. Competitive salary, career growth, and a professional work environment await. Help clients secure their legacies and navigate estate matters with confidence. Apply now by sending your resume. Visit AskTheLawyer.us for details. Take the next step in your legal career with Figueroa & Associates.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa & Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. 8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.